MacArthur. Good evening and welcome to Congress Hall in Independence National Historical Park. I'm Patrick Sedeth, the Deputy Superintendent. We appreciate our partnership with the World Affairs Council of Philadelphia that helps us each year to hold a contemporary discussion relevant to the historic events that took place here so long ago. We are delighted to work with the Council on events like this now and in the future. Ensuring the blessings of liberty, how should the Supreme Court interpret the Constitution, is the title of tonight's program. I can think of no better place to speak about liberty than Independence National Historical Park. Millions visit the park each year to see in person the international icon, the Liberty Bell, its name bestowed by abolitionists. Visitors flock to Independence Hall, where the Declaration of Independence and the U.S. Constitution were debated, adopted, and signed. Liberty is a theme of both documents. Many of our visitors are surprised to learn that the Supreme Court first met in Old City Hall, only a few steps away from here, making some of the first judgments about liberty and justice for our new republic. The importance and power of the Supreme Court certainly has changed since their early years here in Philadelphia. As I'm sure you remember, New York City proudly boasts that it became the first capital city under our Constitution, and Washington, D.C. has been our nation's capital for over 200 years. But for 10 very significant early years, Philadelphia served as our nation's capital. This building was the home of Congress from 1790 to 1800. Members of the House of Representatives hammered out in this room early decisions that were key to the success of our American experiment in self-governance. The Senate deliberated upstairs. And right here next to me is where John Adams was sworn in as the second President of the United States on March 4th, 1797. When he took the oath of office, it was the first peaceful transfer of power between non-related heads of state, a significant milestone in our fledgling government. This is a great room, a great building, and a great park for inspiration and understanding of the foundations of our democracy, and for envisioning our future. And you are a great audience. Thank you for participating. Enjoy the program, which I know will be thought-provoking and inspiring. I'd like now to introduce Craig Snyder, President and CEO of the World Affairs Council of Philadelphia. Welcome, Craig.
Thank you, Patrick. The Council prizes its partnership with the National Park Service and Independence National Historical Park, the ability to conduct important discussions in this truly awe-inspiring setting contributes, I think, mightily to our fulfillment of our mission to promote thoughtful and civil discourse. I also want to thank all of you for joining us this evening. This is the opening event of the Council's 70th program season. You'll be hearing a lot more about our 70th anniversary and our vision for the future of this organization as we go forward over the next number of months. For this program, in specific, I also want to thank the Doran Family Foundation for its support, and I also want to note that this is the latest installment in our Stan and Arlene Ginsberg Family Foundation Great Debates series. As always, we thank the generosity of Stan and Arlene and the corporate supporters Amatec, UGI, and SEI who rose to meet Stan's challenge to create this series. Obviously, we wanted the subject matter and the location for this first program of the season to also reflect the gravity of today's date. For those of us, and I think it's everyone in this room who remember it, it is quite unbelievable that September 11th, 2001 is now long enough ago to be only history for people who will be voting in the next presidential election. But it seems like yesterday, certainly to me, and was, as others have called it, perhaps the worst day in modern American memory. But here we are on another 9/11, even another Tuesday 9/11. What better way to honor the victims of that monstrous attack on American democracy than to celebrate democracy and to practice the free expression and exchange of ideas which are the foundation of democracy? And what better place to do it than in this temple of American democracy? It's quite fitting then that on this memorable date, we renew the fundamental and distinctively American political values codified in our Constitution and debate tonight how the Supreme Court should best and most properly interpret the Constitution of the United States. It has often been said that the Supreme Court is not necessarily the final arbiter of the Constitution, with the awesome power that all that entails for defining the limits of liberty on the one hand and the limits of government on the other hand, that they're not the final interpreter because they always get it right, but rather they are, quote, right because somebody has to be final. But of course, we want the Supremes to get it right. So we're here to talk about how they should try to hit that mark. With us for this discussion this evening are legal scholars, Professor Kermit Roosevelt of the University of Pennsylvania Law School, and Professor Elon Werman, fellow and lecturer in law at the Sandra Day O'Connor College of Law at Arizona State University. Our format will be 2 opening statements of approximately 7 minutes each. We had a coin toss, that's what it said. Elon will go first. Following the opening remarks, we will have a discussion among the 3 of us, and then our guests will have an opportunity for brief closing remarks, and finally, of course, questions from you. To frame our opening remarks, we asked both of our guests to respond to the following statement. Some argue that a legal doctrine called originalism is the best and proper framework within which the Supreme Court should interpret the Constitution. Please tell us your understanding of the concept of originalism and whether you agree or disagree with the proposition that this doctrine should be the guide star for the court's role in defining the meaning of the Constitution. Elon.
Thank you so much, Craig. They told me I can't walk around the building to do this talk, so I decided I'd fidget back here behind the podium instead. I have 7 minutes, 1/4 the time I normally have, to defend originalism, the idea that we should be bound by the original public meaning of the Constitution. The best way to do it, I submit, is to ask, how do we ordinarily interpret law in our legal system? How do we interpret other legal instruments, like contracts or statutes or treaties? Ordinarily, we separate the question of what a contract or statute says from whether the contract is enforceable or the statute is binding. In retrospect, we may not like a contract that we've entered into, and maybe Congress has enacted a bad law. But very much an integral part of our legal system is that we are nevertheless bound, even by the bad contracts that we've properly entered into, and the bad laws that Congress properly enacts. Why? Why, for example, are we bound, even by the bad laws that Congress enacts? Because in our legal system, we maintain that so long as the laws were enacted pursuant to a particular process, a particular democratic process, that confers sufficient legitimacy onto those laws, such that they are binding, even those of them we do not like. Well, can the same kind of argument be made about the Constitution itself? After all, the Constitution is also a law. It's a law we the people enacted to bind our legal officials. So the originalist position is that we first ask, what does the Constitution actually say? What does it mean? What does it do? What legal effect does it have? What kind of constitutional regime does it create? Now, it may turn out that we don't like all of the Constitution's provisions. Maybe we think it's imperfect. Maybe we think we can do better. But is there an argument that the Constitution as a whole is nevertheless binding despite its imperfections, just like the laws of Congress as a whole are binding? even those we do not like. So for the originalist, there are two inquiries. First, we have to figure out what the Constitution actually says or does. But the originalist also has to defend the bindingness of the Constitution, of the original Constitution, such that we should even care what its original meaning is. Well, the originalist approach to the first inquiry is pretty straightforward. The originalist position is that we interpret every legal instrument in our legal system the same way we interpret any communication intended as a public instruction. So interpreting the Constitution is in principle no different than interpreting a recipe for apple pie or fried chicken that you find in your great-great-great-great-grandmother's attic that happens to be dated 1789 and happens to have been written here in Philadelphia. If you found such a recipe, how would you interpret it? Well, you would use a public meaning, not a secret or esoteric or poetic meaning. Otherwise, it would be a pretty ineffective instruction. And you would use the original meaning, the meaning that the creators of the recipe intended to convey at the time it was written. Now, that's not to deny the existence of indeterminacies like ambiguity, vagueness, or breadth. The recipe could say, for example, add pepper to taste. Well, what do we do with that? So it will be the case. It will be the case that faithful chefs trying to implement this recipe will arrive at a range of plausible outcomes in the world, a range of actual fried chickens or apple pies. A range, yes, but it's a circumscribed range. You can't just add rosemary to taste because we don't prefer pepper today. I mean, you could do that, but you wouldn't be interpreting the recipe. You would be amending the recipe. Well, the Constitution is also a public instruction. A public instruction from we the people to our legal officials. So we interpret the Constitution with its public meaning, not a secret or esoteric or poetic meaning, and with the original meaning, the meaning we the people intended to convey at the time it was written. But that's not to deny the existence of indeterminacies. So faithful interpreters of the Constitution will arrive at a range of plausible originalist answers to many constitutional questions. It's that easy. Are we all originalists now? Well, Justice Elena Kagan says we are. But I don't think that's far enough for those who claim that the Constitution of our founders isn't even binding to begin with, because they might say the Constitution is different than other laws. Not only is it old and outdated, but due to historical accident, it happens to be very difficult to change. So maybe we want judges to update the meaning and substance of the Constitution over time as a sort of second best amendment process. What is the argument, then, for why the Constitution is binding, such that we should care about its original meaning? Well, I claim, and because I only have 7 minutes, I'll just say I do so in much more detail in my book, that the Constitution is binding if it is an improvement of the kind that Madison described in a letter to Jefferson. If it is an improvement of the kind that forms a debt against the living. For the Constitution to be this kind of improvement, for it to create this debt, I submit that it must accomplish one major task. It must balance the two principal and competing objectives of a free society. It must, on the one hand, create a regime of self-government whereby we, the people, can govern ourselves democratically. On the other, it must protect a large measure of natural liberty. But these two objectives are in tension. As we all know, it is often popular majorities that infringe on the rights of minorities. So framing a constitution that successfully balances these is no easy task. Well, I submit that the framers were remarkably successful at creating a constitution that successfully balanced self-government and liberty through ingenious mechanisms of which this crowd hardly needs reminding. The separation of powers, checks and balances, the enumeration of power, the representative mechanism itself, the Bill of Rights. But more than that, they wrote the Constitution in such a way, I contend, that it would continue to strike such a balance between self-government and liberty long into the future. Therefore, and in conclusion, so long as we the people today believe and agree that the Constitution of our founders, as it's been properly amended, continues to strike such a balance, then it is an improvement of that kind that forms a debt against the living. And if the Constitution is binding, if it creates this debt, then we interpret it the same way we interpret any other legal instrument, with its original public meaning. Thank you.
Thank you all for coming, and thank you to our host, the World Affairs Council, and thank you to Ilan for a very interesting introductory statement. I mean, I was talking to Ilan before, and we were saying, you know, I think we're not necessarily going to disagree on that much. We'll see. We'll see how that goes. But since I only have 7 minutes, I should start too. And here's how I want to start. My name is Kim Roosevelt, and I'm an originalist. And I say that in that sort of confessional style, right? I'm echoing like the Alcoholics Anonymous introduction, in fact. But I say that in that sort of confessional style because one, politically, let me be candid, I'm more on the progressive side of things. And among progressives, originalism is supposed to be this sort of anathema, dangerous idea. We don't like originalism. And also because I think that I'm here to be the opponent of originalism. Ilan, of course, is defending it. I'm supposed to be challenging it. And I will offer some challenges, not so much to the academic theory of originalism, but more to the judicial practice of originalism. Maybe some of that in these introductory remarks, maybe more of that when we get to the discussion and the question and answer. But let me start now with the question that I was asked to answer, which is, what is originalism, and do I agree that it's the proper way to interpret the Constitution? So what is originalism? As I understand it, it's very simple. In fact, the more interesting points are going to be what originalism is not. And I'll get to that in a second. But first, what is originalism? As I understand it, it's a theory of interpretation. Specifically a theory about interpreting the Constitution, but as Ilan suggested, it's pretty much the way we interpret most things, certainly legal texts. Maybe not novels or poems as much. There, sometimes we might say the meaning changes over time. But generally speaking, when we're interpreting something, originalism tells us this piece of text, this piece of language, had a meaning when it was first uttered, when it was enacted. Maybe it's a statute, maybe it's the Constitution, when it was ratified. It has a particular meaning, and that meaning doesn't change over time. And of course, right, this is the way that we treat most uses of language. If you want to figure out what the recipe tells you to do, you use the original understanding of the terms in the recipe. To take an example from the Constitution, the federal government promises to protect states from domestic violence. And at the time, that meant local insurrections. Nowadays, when people hear the phrase domestic violence, they more often think of violence between family members or intimate partners. So the meaning of the word, the way it's used in our everyday discourse, has changed. Does that mean that the constitutional requirements should change? Well, of course not, right? That would be crazy. Random linguistic drift should not affect the meaning of the Constitution. So that's what originalism is. I think it's pretty straightforward, it's pretty sensible. Texts, pieces of language, they have a meaning when they're enacted or uttered. That meaning doesn't change. Now, what is originalism not? First off, originalism is not a theory of adjudication. It tells you how to figure out the meaning of the Constitution. It doesn't tell you how to decide a case if you're a judge. And there are two reasons for this. One is, in most of the areas where the Supreme Court gets constitutional cases, there are a lot of decisions already out there. There are precedents. And there's a doctrine, the doctrine of stare decisis, which tells the court it should usually follow its precedents, unless it has a particularly good reason not to. And the fact that an earlier decision is mistaken is usually not a good enough reason. So, originalism as a theory of interpretation doesn't tell you what you should do about contrary, non-originalist precedents that might be out there. People have theories about this, but I don't think that originalism itself tells you what to do. Second reason originalism is not a theory of adjudication is that deciding a constitutional case requires judges to do a lot more than figure out the meaning of the Constitution. In fact, if you look at Supreme Court cases, even non-originalist ones, most of what they're doing is not saying what the Constitution means. It's coming up with some complicated multi-factor test, which they then use to measure the constitutionality of some government action. And these are complex multi-factor tests, not just statements about the Constitution's meaning, because the court is trying to do a lot of different things. Yes, we want to know what the Constitution means, but when we're deciding a case, we're actually trying to come up with a good rule that will implement or enforce that meaning. And we might be concerned about giving guidance to courts, lower courts, and government officials. We might be concerned about giving adequate deference to the views of coordinate branches of government, or the states, right? When government officials act, presumably they think what they're doing is constitutional, so should the court defer to that? Sometimes yes, sometimes no. The court might be thinking about the costs of error. How bad is it if we mistakenly uphold an unconstitutional law? How bad is it if we mistakenly strike down a law that is constitutional? Which direction do we want our errors to skew? So there are lots of other factors that go into this. Originalism is not a theory of adjudication. And last, my most important point, even when it is a theory of adjudication, even if we're just asking what does the Constitution permit, what does it forbid, originalism is not an argument that cases should come out the same way today as they would have if they were brought at the time of the ratification of the relevant constitutional provision. A lot of originalist argument, particularly by judges, seems to think that this is so. So if segregated schools are permissible in 1868 when the Equal Protection Clause was ratified, they must be permissible in 1953. But this is not true. And as a way of demonstrating that it's not true, I'm going to consider a constitutional clause that we don't have called the latest fashions clause. So suppose you want the Senate to be respected. You think that the key to being respected is dressing fashionably. You put in the Constitution a clause that says, senators, while engaged in debate, shall wear the latest fashions. Clearly, this tells you to do one thing in 1788 and another thing in 2018. It tells you that conduct that complied with this constitutional provision in 1787 is going to be unconstitutional in 2018. Not because the meaning of the Constitution has changed, but because the Constitution itself tells you to look to the latest fashions. It tells you to look to current standards. And in most of the controversial cases, particularly equality cases, like Brown v. Board of Education about segregated schools, Loving versus Virginia about interracial marriage, or most recently Obergefell against Hodges about same-sex marriage, the question is, do we have to have a fixed set of applications so that outcomes can't change, or might the Constitution in fact specify a standard that looks to current contemporary facts or values? That's an important question, but it's not a question about interpretive methodology. That's a question about the meaning of particular constitutional provisions. So the purported debate there between originalists and the living constitutionalists, I say, is actually not a real debate. It's a disguised disagreement about the meaning of particular provisions. But now I've gone on for too long, so I should stop. Thank you.
Thank you both. So you are obviously both eminent scholars in these matters, and that's why you're here. But our audience, I think, is here predominantly as citizens. And so a lot of what I want to talk about will have a less technical and more political cast to it, and I'm sure you're not surprised by that. So Kermit, I want to start with you, and I want to offer a bit of a narrative that will be entirely familiar to you, but ask you to sort of react to it. So for most of American history, American children prayed in public schools. A whole host of behaviors that people thought had sort of moral content and consequences were regulated by the laws of the states and varied from state to state in many cases. The legal status of abortion and of many forms of association and of different aspects of sexuality were predominantly state-regulated activities. Then, in the space of a generation, the Supreme Court of the United States removed from state and local officials and the political majorities who elected those people the ability to regulate these items because the Supreme Court said the Constitution must be read to require certain outcomes on these questions and therefore limit the power of government to do anything other than what the court said the Constitution requires. So, my question to you is, when people say they sort of yearn for originalism, are they not really saying they yearn for a return to having many of these controversial questions decided through the majoritarian political process rather than determined by the Supreme Court.
Is that what they're saying? I'm not so sure about that. I mean, on some issues, people yearn for originalism because they think it will give them less judicial involvement and more democratic resolution of controversial problems. On some issues, people seem to yearn for originalism because they want more judicial involvement. They want the courts to push back more against the government and keep the government within a founding era or possibly Reconstruction era understanding of legitimate government purposes and powers. So I think there is an ideological valence to originalism. I mean, what you're describing is a preference for democracy, which sort of sounds good, right? Except that the counter-argument to that is on some issues, minority rights should be up to majority vote. And there are particular constitutional provisions where we've said, no, this is something majority can't do. Usually because we've experienced a practice and we think it was bad and we're not going to do it again. But sometimes maybe with the unfolding contours of liberty, because we've decided liberty in the abstract is an important value. But what would I say about this more generally? Well, to a certain extent, the people who say, hey, all these things used to be left up to the states, they're right. But that was before the Civil War and Reconstruction and the Reconstruction Amendments. Now, in possibly the first famous speech about originalism by Attorney General Edwin Meese, he actually said originalism is good in part because it will reverse the decisions that apply the Bill of Rights to the states. Most scholars, I now believe, think that he was mistaken about that. There is a good originalist justification for applying the Bill of Rights to the states. There's a separate question, what do these Bill of Rights provisions mean? But what I was going to say was, to the extent that politically there is an ideological valence to originalism, it comes from what I described as the sort of mistaken idea that originalism means a practice that was acceptable at the time the relevant constitutional provision was ratified can't become unconstitutional. If that's your version of originalism, it's going to be very useful in fighting back against emerging constitutional equality movements. And to the extent that you see judges doing that, I sometimes wonder, are they really interested in originalism or are they interested in pushing back against these emerging constitutional equality movements? My takeaway, my conclusion for all of this, I'll just tell you now, why not, was going to be there's nothing wrong with originalism, but there is something wrong with at least some originalist judges. So I have a little bit more skepticism about the way originalism is judicially practiced.
Thank you. Okay, Elon, I want to go kind of the opposite side of that question, right? So, a lot of critics of originalism, or at least the way it's practiced, as Kermit has said, say that it's essentially it is an academic cover for a conservative political ideology and the desire to impose or reimpose that on the country to overturn this sort of, this generation of a more progressive court that I was describing earlier. Who's right about that?
The answer is some of the critics. It's true, right? Some originalist judges do unfortunately use this method of interpretation in order to arrive at their preferred political results. Right? But this is going to be true of any method. And certainly originalism is less amenable to such manipulation than alternatives, which basically say, well, you know, which 5 methods of interpretation do I feel like doing today to get to the result that I want? So the first thing to say is that I think originalism, although it is liable to be abused, I think is less liable to such abuse than other methods of interpretation. Originalists have to take the bitter with the sweet thing. You might think taxation is theft. Well, too bad, it's right there. Congress is allowed to tax you. Right? You might think that senators ought to be elected by the state legislatures again, but too bad. Right? The second thing to say is, again, properly done, originalist does not necessarily lead to modern day conservative political results. I'll give you an example. This is my favorite example because it's recent. Title VII, by the way, I don't distinguish between statutory interpretation and constitutional interpretation. This is somewhat controversial. I don't understand why it's controversial. I think it's the same method, different text. But Title VII of the Civil Rights Act of 1964 prohibits discrimination on the basis of sex. Does that include discrimination on the basis of sexual orientation? Well, there was a recent case in the Seventh Circuit called Hively v. Ivy Tech, where there were conservative originalist judges in dissent who said, no, could the Congress of 1964 possibly have imagined, possibly have thought that it would apply, to sexual orientation discrimination? This is the wrong question. As Professor Roosevelt said, what matters is what they wrote, not what they would have thought about things they couldn't possibly have imagined or conceived at the time. And so there were two conservative originalist judges in concurrence who said, wait a minute, it says sex has to be a motivating factor in the discrimination. I don't see how sex isn't a motivating factor in discrimination on the basis of sexual orientation, because to discriminate on the basis of sexual orientation, you have to know someone's sex, think they're not conforming, acting in conformity with how someone of that sex should behave. So yes, it covers sexual orientation discrimination. I think that's the right answer. And another example of how it doesn't necessarily lead to conservative results. But I think the most important point is, more often than not, this goes to the question you proposed, Professor Roosevelt, originalism doesn't require a conservative, liberal, progressive, or libertarian result. Most of the time, it leaves the question to the democratic process, where sometimes liberals will win, sometimes conservatives will win, sometimes libertarians will win, and sometimes progressives will win.
Let me stick with you for a second. Kermit brought up Brown versus Board of Education, which probably most Americans would think is the finest hour of the Supreme Court. So there are critics of originalism who say originalism can't account for Brown. And if that's so, then originalism must be a bad idea. So can originalism account for Brown, and if so, why?
Yes, Brown v. Board is an easy case under originalism. And by the way, I also push back slightly on the premise. I don't think most originalists today would say you can't justify Brown. But certainly you can't justify Brown on the reasoning of the court. But you can justify it under the original meaning of the 14th Amendment. Again, it's an easy case. Not under the original meaning of equal protection. This is a separate question, a separate debate. Equal what? Equal protection of law. It's very different. It's not equal laws. It's not equal everything. But I do think it's very easy. Brown v. Board is an easy case under the Privileges or Immunities Clause of the 14th Amendment, which says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. There is abundant historical evidence that what this provision meant is that whatever privileges of citizenship a state chose to accord its citizens, it had to do so equally to whites and blacks alike, and to citizens of every other color. What does this mean? Once public education becomes a privilege of citizenship, if you're a citizen, you are entitled to go to public schools and public education, once that premise is established. And once it becomes known what every proponent of the segregation laws in the South knew, which was the purpose of the segregation laws, wasn't separate but equal, but to actually keep one race of Americans in a perpetual condition of inferiority and subordination, once that becomes known, Brown v. Board is an easy case. Because separate but equal is not separate but equal. It's an abridgment of the privileges or immunities of citizenship. It's giving one class of citizens more privileges and immunities than another. I think Brown v. Board is an easy case.
Kermit, let me come back to you on the question of the court following precedent and the relationship to the debate about originalism. So, again, in the ping pong of our politics, we sometimes see progressives very much interested in the court following precedents, certainly with respect to Roe, and yet we see the same argument made on different policy issues related to different cases by conservatives. There doesn't seem to be a consistency about support for the value and importance of precedents. It seems to be sort of chosen case by case, depending on the outcome that somebody wants. Right? So, again, to go back to a little bit more of theoretical construct, what do you think the relationship is between the originalism that you've professed to be a part of and the proper way to handle cases that the court believes were wrongly decided before?
Well, it sort of depends on why the case was wrongly decided, or why it now looks wrongly decided. So, is there a consistent theory of how to approach precedent that explains either what the liberals do or what the conservatives do? Probably not, because they're political actors. And there are law professors whose hearts are pure, and then there are judges and politicians out there in the world who are motivated by politics. That's not true of everyone necessarily, but I do think that most law professors are actually trying to give you their best understanding of particular constitutional questions. Judges think they're doing that too, I think. Maybe the politicians are the worst, the elected officials. Judges think they're doing that too, but the judges are affected by their own life experiences and ideological priors. What I was going to say, and it relates to what I was saying about my understanding of originalism, is it's possible to say this decision, let's say Plessy v. Ferguson, was actually right when it was decided, but now it's wrong. And how could that happen? Well, it could happen if you think that the purpose of the Equal Protection Clause, and actually I agree with Ellen, should be the Privileges or Immunities Clause. Long story about why that's so. But let's just suppose we have a constitutional prohibition on invidious or unjustified discrimination. How do you decide what is invidious or unjustified when a state says black children must go to a different school than white children? Well, one way you could do it is you could ask, what did people think in 1868? And that would be a certain kind of constitutional provision, but I think not a very good one, because anyone with any sense is going to understand our views about what's appropriate change. Social movements come along and make us think a certain practice that once was natural and accepted is now seen as invidious, oppressive, stigmatizing. So if you're smart, you probably wouldn't want that kind of constitutional provision. And I believe the drafters of our Constitution were smart. So another thing you might do is you might ask judges to figure out, as a matter of moral philosophy, what's really justified, what's really equal. I don't like that approach. I don't like giving that much power to judges. I don't think judges are necessarily better at figuring out what's morally justified than ordinary Americans. So the other thing you might do, and the thing that the court actually tends to do in these equality cases, is look at national consensus. And in a whole bunch of these equality cases, basically what happens is there's a practice that appears normal and natural, and everyone is like, yes, of course we treat these people differently because they're different. And then a social movement comes along and says, we're actually not so different. What we're asking for is not some strange different treatment. We want the same things that you want. We're not so different from you. And then society changes, and you get a national consensus. And sometimes this is reflected in state court decisions, sometimes it's reflected in state laws, so you can get objective indicators for this. But you get a national consensus that says, yeah, what we thought was natural and justified is actually oppressive and arbitrary. And now it's unconstitutional under this provision that prohibits arbitrary or oppressive or unjustified discrimination. And if that's the case, you shouldn't have any hesitation in overruling the precedent. So when Brown overrules Plessy, that's what it's doing. In both cases, they're saying this constitutional provision prohibits arbitrary, oppressive, or unjustified discrimination. They've just changed their mind about what is arbitrary, oppressive, or unjustified. Overruling Roe would look different, because Roe is saying, as part of the meaning of the Constitution, there is some specially protected liberty right here. Overruling it, you would be saying, no, there isn't. So it looks a little bit different. So if you're trying to say, Roe should be respected, but the bad cases like Bowers or Plessy shouldn't be, that's a way that a liberal could do it.
Any comment there?
The same issue? Sure, so the one thing I'll say about precedent is that, first, it's the one big elephant in the room that I did not address in this book because it's so hard, and originalists disagree among themselves, and I wanted to keep it to 135 pages, so it's a nice, quick read. But what I will say is I do think a consensus is forming on how to handle precedent. And the first thing to say, if it's true, what I said before, that originalism might lead to a circumscribed range of plausible answers due to ambiguity or indeterminacy, then certainly it's okay to stick to precedent if that precedent is a choice within that range of original meaning. One of my favorite examples, and this theory of how to settle meaning and practice over time, Madison refers to it as liquidation, liquidating the meaning of ambiguous constitutional provisions through a series of discussions and adjudications, not just among the court, there was no judicial supremacy at the time, but among the courts, Congress, the executive, the states, and the people themselves. One of my favorite examples is the Bank of the United States. There's a big debate, happened right here, I guess where we're sitting, over whether the Bank of the United States was constitutional. It's not perfectly clear, not at all, not even close. If you look at Article 1, Section 8, does Congress have an enumerated power or a necessary and proper power to incorporate a national bank. Madison thought not. He thought it was unconstitutional. But everyone else pretty much disagreed with him until you get to the Jackson era. Anyway, Congress enacted the bank, the president signed the bank, I think it was even rechartered once. The court upheld the bank as well, the constitutionality of the bank. Then Madison became president of the United States, and he was confronted with rechartering or vetoing the bank. And he refused to veto the bank on his previous constitutional grounds because this is my words now, he basically said, look, I get that it wasn't a clear constitutional question. My view lost. It's been settled over time through these different institutions. The constitutionality of the bank is settled. To the extent that that's what precedent is, easy case. The real question is, what do you do when a precedent is outside the bounds of that range? Well, this is hard because people disagree about what that range really is. And so I think the answer is, if the precedent is clearly wrong, if it clearly violates the original meaning, if there was no indeterminacy, no ambiguity in the original meaning of the Constitutional provision, then I think you can overturn it. But of course, you also have reliance interests and other things that have developed over time. Suppose you think Social Security is unconstitutional. You can't just take that away overnight, for example. So there are political considerations that have to go into it, because by hypothesis, you already are dealing with a non-originalist precedent that brought in non-law or presumably political considerations into the original deviation from the original meaning of the Constitution. All that may be controversial, but that's basically my view.
What's the difference between textualism and originalism? And which one do you believe Judge Kavanaugh espouses? In any order that you want.
I think we might get some disagreement here. Oh, go ahead.
Well, as I understand it, textualism is more probably used in statutory interpretation. I think there's more of a debate about textualism and statutory interpretation than there is with constitutional interpretation. But textualism is basically the idea that in interpreting a statute or the Constitution, judges should look at the words and they should stick to the words. So they shouldn't deviate from the words if they think doing so would better serve the purpose of the statute. And they shouldn't, some people say, look to legislative history, look to reports about a bill, look to the debates in Congress, look to what the sponsor said, because those things are not the law, only the words of the statute are the law. I'm not sure that I agree with that. I think legislatures enact laws for particular purposes, and applying them in a way that is blind to those purposes is probably not a great idea. One interesting point about the difference between constitutional and statutory interpretation is that even originalists and textualists actually do look at something that looks sort of like legislative history when they're interpreting the Constitution, which is the Federalist Papers. They love to cite the Federalist Papers. And yet, what are the Federalist Papers but statements by the proponents of the Constitution, trying to induce people to vote for it? It's exactly the same thing as legislative history, speeches in Congress. So that's interesting. I think there's actually an explanation for that. But originalism is a theory about how meanings change or don't change. And textualism is a theory about what we should look at in trying to figure out what a statute means. So they're focused on slightly different things. They often run together. I'm not exactly sure why.
Yeah. So that's actually the most sensible explanation of the distinction that I think I've ever heard. I once attended an entire conference. I think it was the Federalist Society. The entire conference, textualism versus originalism. 4 or 5 days. And I asked people, what's the difference? What's the difference? I don't get it. And I never really got a satisfactory explanation. I mean, the way I see it, the way that it's been explained to me, right, is that textualism, you just look at the text and in the 4 corners of the text, and you don't look sort of at anything else. I don't think that's a sensible way of interpreting any text. That's not textualism. That's not how sensible people interpret any text. Text only has meaning in context. It helps to know the purposes for which the text was written, the intent of the legislators, the background principles of law against which they were legislating. All of these things help us figure out what the text actually means. What's originalism? I think that's exactly what originalism is. You go with the text. Originalism stands for the proposition that the original public meaning of the text is the law, where it's clear. I think that's textualism. If the difference between textualism and originalism is that, originalism is willing to make other things other than the public meaning of the text the law, then I guess that's different. But most originalists I know don't do that. Most originalists I know will say, if the founders had an intent with respect to something, but they wrote it wrong in the Constitution, I don't think they say the text isn't the law. They don't say the original intent is the law, even if the text clearly contradicts that intent. So I don't really see a difference, though I'll have to think about what Professor Roosevelt said, because that sounded quite sensible.
All right, let me go at this a little different way, and talk about the folks who say they are not originalists but believe in the concept of the living or evolving Constitution. So on the bicentennial of the Constitution, Justice Thurgood Marshall gave an address, I'm sure you're familiar with, in which he said there was no reason for the court to pay special deference to the meaning or the intentions of the founders, because he said the Constitution was, quote, defective at the start, especially because of slavery and the denial of women with the right to vote. How do each of you think you would respond to what the eminent Justice Marshall said?
I would say, yeah, the Constitution was defective at the start. We improved it a lot with the Reconstruction Amendments in the 19th Amendment, but actually it's still defective, I think, in lots of ways. We could have a better Constitution. I'm not sure that equal state representation in the Senate is a good thing, especially given the vast divergences in population that we're getting now, which didn't have at the time of the founding. Is it right that California and Wyoming have equal representation in the Senate? Not so sure. Should the president have a fixed 4-year term, or should we have the possibility of something like a no confidence vote? Should Supreme Court justices have life tenure, or would it not make much more sense to have them with fixed 18-year rotating terms? Lots of ways in which the Constitution could be improved. But what does that mean? The Constitution is not perfect. Of course it's not perfect. I find it hard to believe that that means that judges should be given the power to change it. Now, I mean, one thing that's maybe not perfect about the Constitution is how difficult it is to get an Article 5 amendment. It's been a while since we did that. People seem frustrated with some features of the Constitution. Maybe that's a problem too. But my solution would not be to give the power to judges.
I think I agree with all of that. I will say, and this is going back to my remarks and sort of the arguments that I make in this book, the Constitution doesn't have to be perfect to be binding, right? If that's true, then, well, who gets to decide if you don't like a particular provision, and then you get to change it, the people get to change it, a judge gets to decide, so it doesn't have to be perfect for it to be binding. But it does on the whole have to be just. It does on the whole have to accomplish what a constitution for a free society must accomplish if it's going to be a good constitution, an effective constitution for that society, balancing self-government and individual liberty. If today we didn't have the Reconstruction Amendments, and God forbid we still had slavery or something of that sort, then I think the Constitution would be so defective that it would no longer strike that balance and it would no longer be binding. And in fact, I don't think the Constitution was binding on a single slave. They had every right of revolution because the Constitution did not successfully balance their rights to self-government and individual liberty. But of course, this is academic, right? This is sort of moot and hypothetical because at the time the Constitution was written, it was an innovation. Right? It abolishes hereditary privileges and titles of nobility, has no property requirements for holding federal office, right? It creates the first free government of the modern world. Like, these were innovations, right? And today, we've evolved, we have a more progressive mindset, and because we've evolved and have a more progressive mindset, we've changed the Constitution along with us. So it's kind of a moot and hypothetical question to say, well, what if we have our modern sensibilities, but we hadn't amended the Constitution to go along with it? Would it be, I guess it wouldn't be binding in that case, but of course we did change it.
So I can't get you guys to disagree as much as I'd like. Apologize to the ticket buyers. But let me try a different tack. When we all leave this room with the thoughtful discourse that you're giving us,
But not discord.
Exactly, not discord. But when we leave this room, we go out into a world of a lot of discord, right? I was in Washington on Friday, and I walked past the United States Supreme Court. And on one side of the building, there was a lot of posters that said, Roe is more popular than Kavanaugh. And then I walked to the other side of the building. And on the other side of the building, there was a giant poster that said, school shootings are God's revenge for killing his babies. That's a piece of the America that exists outside this room. It seems like the days, and it wasn't that long ago, when Supreme Court nominees were regularly confirmed with large, overwhelming bipartisan majorities, and the inquiry in the confirmation process was about something called qualification. Clearly, there's not much, if any, of that process left, of the court and the selection process for the court being above politics. It appears that, looking at those posters, watching TV, et cetera, that the confirmation process has become one of the most heated fronts in the red versus blue cold civil war that the country may well be in. So my question to both of you, taking off your professor hat and putting on your citizen hat, but very informed citizens, is can the rule of law survive a political climate in which the court and its process of interpreting the Constitution is the most heated political debate?
Can the rule of law survive? Well, you know, I feel like I'm an expert on some things. I'm not an expert on whether the rule of law can survive. My guess is, sure, we'll come out of this okay. I'd be more worried about various other kinds of looming catastrophes that will destroy human civilization. But setting that aside, I think we are in an unpleasant political time, and Supreme Court appointments are looked at as political spoils, and that's bad. We've had similar situations in the past. You know, we had senators used to cane each other. The size of the Supreme Court has been expanded and decreased to deny presidents appointments or grant them extra appointments to overcome the fact that earlier they were denied appointments. And we look at that now as terrible, right? Because the last time it was tried was FDR's court packing plan, and it was defeated, and people said, that's a terrible assault on judicial independence, and we'll never do it again. But in the past, people did it successfully for partisan reasons. There was also a civil war, like a real hot civil war. And that was bad, but you know, we survived. So I think the rule of law will make it. Like I said, I'm not an expert on predicting that kind of thing. There are very interesting questions as to why we have the degree of polarization that we do and what can be done about it. And lots of people are doing interesting work on that, but I'm not actually one of them.
So Craig, the first thing I'll say is I'm not sure I can take off my academic hat because, you know, this is my first year teaching, and my brother is also a public school teacher up in Boston, and when I first got this job, he said, just remember, Elon, being an academic is a 24/7 job. 24 hours a week, 7 months a year. Okay, so I'll take off my citizen hat. Okay. Yes, he's very funny. The confirmation battles have become political because I submit the court's opinions sound political. They look political, right? Alexander Hamilton said that judges, courts should exercise judgment, not will. When a Supreme Court opinion looks more like an act of legislation, then you can see why people get riled up over confirmation battles. So my point is that methodology matters. Methodology matters. If there was some way for the court to look like it was actually doing law, I submit by being more originalist, then even if it sometimes led to results you don't prefer, I think we would all be better off. And I want to give one example. The Obergefell case, the same-sex marriage case. When you read that opinion, I have trouble reading that opinion and thinking that this feels like law. It doesn't feel like law. Why? because it was decided under this nebulous, amorphous concept of substantive due process, which for the uninitiated means not only does the Constitution mean the states can't infringe under the 14th Amendment, cannot infringe rights actually enumerated in the Constitution, but also unenumerated rights. That over time we the court identify as fundamental. So it protects unenumerated rights written nowhere. Who gets to decide? The Supreme Court over time. Read the opinion. It's meandering, it doesn't feel like law. Is there an argument, an originalist argument that gets us closer to doing law, but it actually might justify the result in Obergefell v. Hodges? I think so. I'm not committed to this answer. I don't know if it's the right answer. But again, under the Privileges or Immunities Clause, if it means that whatever privileges or immunities a state does confer on its citizens, it must do it equally. Okay, there's a definitional problem of what marriage is, fine, I get that, but it's not beyond the pale to make the argument that today so many privileges and immunities attached to this right of marriage that it must be given equally to all citizens alike, even gay citizens, right? I'm not saying that's the best originalist answer, and it may be wrong, but if the opinion had been written like that, at least everyone would have thought that the court was making an honest attempt at doing law. And so long as the court doesn't make that kind of attempt, I can see why our confirmation battles will stay as they are.
Neighbor Jones?
Well, it's
We agree.
No, I was going to say, isn't it pretty to think so? Because my sense is that there have been highly partisan attacks on the court in the past, and it's not because the justices aren't being originalist enough. I do agree that the Kennedy opinion in Obergefell is kind of a mess, and that it could have been written much more clearly and probably would have been more persuasive if it hadn't been written the way it was. And what can you say? I mean, it has to do with the peculiarities of the author. In some ways, Kennedy likes to write in these grand, majestic generalities. I would have written it differently, but I would say two things. I would say, one, I'm not entirely convinced by the idea that our current difficulties result from the fact that Supreme Court opinions don't read legalistic enough, because I don't think that the American public really is looking for legalistic opinions. And even if that were the case, I'm not so sure that originalism is the answer, because you can get a very doctrinal, boring, legalistic opinion that doesn't use any odes to dignity, which Kennedy is very fond of. Everything for Kennedy is about dignity. But anyway, you can get a very legal sounding opinion that's non-originalist. All you have to do is look at all the precedents and set out the tests, and it sounds very much like law and not policy. Now, it might actually be a disguise for policy preferences, but unfortunately, I think sometimes so is originalism, because you can have a situation where the answer is not clear, as Alan was just saying in this case, perhaps. And then you play up the evidence that supports you, you downplay the evidence that doesn't support you, you reach your preferred conclusion, and you can make it sound originalist. But probably people won't be fooled. So I guess I would say originalism is no better than doctrinalism at making the American people think that you're doing a lawyer's job and not a politician's.
Okay, I want to get to questions from the audience and have ample time for that, so I'm going to ask each of you to make whatever closing remarks you'd like, and we'll go in the opposite order from the start. So, Kermit, if you would go first.
Okay, well, so my closing argument, I already gave it to you. It's that you don't really need to worry about originalism. Originalism is fine. Originalism is very sensible. There are arguments to be had about what kind of provisions we have in the Constitution. And in particular, maybe the Equal Protection Clause, or if you're an originalist, the anti-discrimination aspect of the Privileges or Immunities Clause. But the provision we have that forbids states from engaging in oppressive discrimination is that a fixed range of applications, things that people thought were oppressive in 1868, or is it to be determined by something like national consensus? That's a legitimate argument to have. I think it would be stupid to write a fixed set of applications provision for that kind of a constitutional provision. And I don't think that the drafters of the 14th Amendment were stupid. So I think it makes a lot more sense to view it in the way that I've described it. But in any case, that's a substantive argument about the meaning of a particular constitutional provision. So you don't really need to worry about originalism with respect to that. You do possibly, I was going to say, need to worry about originalist judges. Because originalist judges, virtually without exception, when they come across a question, like, could a practice that was widely accepted and largely unchallenged in 1868 be unconstitutional now, tend to say no. And they tend to say no as if it follows directly from originalism, which I said it doesn't. But they tend to do this, and they tend to do this even though for 20 years, the view that I'm putting forward has been widely understood and largely accepted among originalist law professors. So for some reason, the sophisticated, open-minded originalism in the academy, like that of my friend here, isn't penetrating into judicial practice. Another thing that judges do is they're selective originalists. So if you look at the conservative originalist justices attacking affirmative action, Scalia and Thomas in particular, they're the originalists, or they were the originalists. You don't really see a whole lot of inquiry into the original understanding. Generally, you don't see a lot of attention paid to Reconstruction. They're much more interested in the understanding at the founding. But if you're a good originalist, you've got Reconstruction amendments. You should be thinking about Reconstruction. So I'm much more skeptical of the way that originalism is practiced by some judges. As simply a theory of interpretation, I think originalism is sensible and largely benign.
Thank you again for hosting us, and thank you for the excellent discussion. I guess I'd conclude with the following point. Again, sort of going in reverse order from what I said before. To be binding, the Constitution doesn't have to be perfect. It has to balance self-government and individual liberty, and it can do it in many different ways, right? So just because you think it could be done in a different way doesn't make it not binding, so long as on the whole we, the people today, agree that it accomplishes that objective. And if it's binding, we treat it just like we treat any other binding law, with its original public meaning, not the original expected application, a key point of agreement between me and Professor Roosevelt. Right? What matters is what they wrote, not how what they wrote, how they thought what they wrote would apply to particular situations, although of course that could be evidence of the meaning of the text. But what matters is what they wrote. Now, what they wrote often leads to conservative results, liberal results, libertarian results, progressive results. Originalism is more constrained than the alternative. Would we rather have a conservative living constitutionalist? I don't think so. I think that's less constrained. Originalism, we are bound by the original public meaning. This doesn't necessarily lead to particular liberal, conservative, whatever political balance results in the modern day to modern problems. But I will close on this point. I do think there is some connection between originalism and conservatism, but that this is a connection to be embraced. Properly understood, and it's often not understood this way, what is conservatism? Conservatism means nothing outside of a particular context. Conservatism means to conserve something, but what? Well, in the American context, I submit, conservatism means conserving the traditionally liberal, the classically liberal principles of the American founding: self-government, ordered liberty, and equality under law. And what is originalism? Well, originalism is the method of interpretation that says we are bound by the original legal content of the Constitution that was created to give life to those principles. And so there is a connection between them. But that connection allows for endless opportunities all across the political spectrum today. Thank you.
Thank you. Okay, I see Kelly with a microphone, and I can't really see this side of the room because of that light. But if you can find some folks, we'll go back and forth.
I'll sit down, actually, since you are. Thank you both for speaking here today. It was fantastic. I have a question to both of the speakers. Professor Worman, in your opening statement, you likened the Constitution to a document that is unchanging, as though it was the same document that would be a recipe, for instance, from your ancestors. And I will give a personal anecdote. The recipes that my mother gives me are sometimes hard to interpret. How much water to put in the rice? Well, a finger's worth. And the Constitution that we have is a famously short document compared to a lot of constitutions across the globe. And it seems as though the founders deliberately kept it that way, that there was meant to be room for expansion and to fill in the gaps, either through future societies, judges, or legislation. Do you think that the length of the text, and it's only 5 articles, and for whatever reason they decide to spend an inordinate amount of time discussing how Congress shall fund all the postal roads, but don't decide to describe what cruel and unusual punishment is, for instance, do you think that that has a bearing and effect on what originalism means and what the room for interpretation has led us to?
So first, don't hate on the postal roads. Like, there are a lot of interesting debates in Congress and the Supreme Court. They're all post office cases. Why? Because the post office was the biggest administrative part of the executive branch. The first debate about delegation of power was over whether Congress could give the Postmaster General the power to make post roads at his discretion. Now, of course, post roads was the 1790s equivalent of pork barrel projects, right? I mean, it's the life or death of town. So anyway, slight defense of the post roads. Someday I'm going to write a book about this, about the post office cases and why they're great. But your point is correct. Recipes can be hard to interpret, and so can the Constitution. But I guess my point is that the exercise is the same. It is ultimately an exercise in trying to discern the original public meaning of the text, right? You don't say, okay, 1 finger's worth, well, I guess I'll put in a whole gallon. You wouldn't do that. That would be unreasonable. Why? Well, because it's clearly outside the range of the meaning. So the meaning can be indeterminate, but it's not unbounded. And to that, I will say yes, the provisions of the Constitution are sufficiently capacious to apply to new circumstances. Right? So the First Amendment protects the freedom of speech. It applies to speech made on the internet. The Fourth Amendment protects against unreasonable searches and seizures. That applies to GPS devices that police officers put on your cars. These are 3 things the founders probably could never have conceived of. But notice what we did there. All of that is consistent with the meaning. The application of that meaning might change over time as society evolves, but the meaning doesn't. Now, some provisions may be so broad that really they're open-ended invitations to just pour our values and change over time. People often say due process of law, equal protection. This is actually my next point. These provisions were not as broad as Justice Kennedy's opinion of Roosevelt would have you think, but neither were they so narrow as Justice Scalia's alternative would be. They had fixed historical legal meanings that allowed for application to new circumstances, just like the First Amendment or the Fourth Amendment. They were not open-ended vehicles to pour values into, but they were sufficiently capacious to be adapted to future circumstances. And that is the genius of the Constitution, that they wrote it precisely in that way.
So, what would I say about that? Well, I think that's a great question. And I think it highlights what I think is a particular weakness, again, not of originalism, but of particular originalist judges. Who tended to say, and I'm thinking mostly of Justice Scalia here, there were plenty of things I liked about Justice Scalia, but what I didn't like was his tendency to suggest that he was the only principled person on the court, and sometimes maybe Clarence Thomas, but that really he was the only principled person on the court who was exercising fidelity to the Constitution and everyone else was willfully making it up. Because originalism, I think, is a good starting point, but very often will not give you an answer. And then, regardless of how originalist you want to be, you really have to turn to something else. You have to turn to some other interpretive methodology, or you have to start thinking about something other than original meaning. And an illustration of this that came to mind while Ilan was talking is the Bank of the United States. So, if you look at the records of the Constitutional Convention, they discussed whether Congress should be given a specific power to charter corporations, and they voted that down. So if they voted yes, then Congress clearly could have established the Bank of the United States. They voted it down. Congress does have all these other powers. Could you use some of them? Well, hard to say. Hamilton and Madison, of course, disagreed on this. It was debated in Congress. It was debated in terms of constitutionality. And Madison was saying to the members of Congress, vote no because this is unconstitutional. They voted yes. Some number of people, you probably know this, but I don't, some number of those members of Congress had been present at the Constitutional Convention. They were delegates. And they split. they divided. In the Senate, same thing happens. People who are at the Constitutional Convention divide on the question of whether Congress has the power to create a bank, which was actually kind of discussed at the convention. So how many years after this, after the convention is this? I'm not sure, but not very many. Relatively soon after the convention itself, people can't agree. What power did we give Congress? Did we give it the power to create this bank or not? So the idea that now we who weren't there at the convention and didn't discuss this and don't know all of the things that they know can figure out what they decided for issues that they didn't discuss and could not possibly have anticipated seems a little bit unrealistic with respect to lots and lots of issues. So the lesson that I would take from this is, yeah, the Constitution is hard to interpret. It's short. It doesn't give you a whole lot of definite rules. And so there are lots of cases in which originalism just isn't going to give you an answer.
This may be a little esoteric and down in the weeds, but I'm going to ask it anyway. I'm a patent attorney, and the Patents and Copyrights Clause ends by telling us that Congress shall protect the discoveries of inventors. Our most conservative justices have, over the course of the last dozen years or so, literally written the word discoveries out of the law. The most recent of these decisions is the Alice decision, a unanimous decision of the court written by Justice Thomas. How does an originalist come to completely ignore a word clearly stated in the Constitution?
Well, so I will fall back on my standard dodge, which is originalism is a higher order methodology, right? It applies to every constitutional question, thousands of them. I haven't studied this one enough, such that I'd write it in a large article and feel comfortable talking to you about it. But having said that, based on what you've told me, little known secret until about 5 months ago, I sort of practiced patent law. So I'm familiar with the Alice and the Mayo cases and all of that. And the idea is you can't patent laws of nature, right? So Einstein couldn't patent general relativity because it's building block of science. Everyone is sort of free and accessible to everybody. I had never thought about how that conflicts with the patent clause. But maybe that's a law review article in waiting. I'm sorry that I don't have an answer to the question. I don't know the answer. It's intriguing.
You can get a collaboration.
Yeah, that'd be good. I have an introduction number of 7. If that matters to you.
Yeah, so I would say that depends on the original understanding of the word discoveries. And I don't know what that original understanding was. It's possible that Justice Thomas does know, and he's doing the right thing. Or it's possible that Justice Thomas is abandoning his originalism because it's inconvenient, which I've been saying I think he does sometimes. So affirmative action cases, a bunch of free speech cases, attacks on campaign finance reform, I think hard to justify under the original understanding of the First Amendment. In a number of cases, originalist justices just don't act that originalist. And it's not because originalism doesn't give an answer there. It gives just as much of an answer as it does in other cases. I do think it's because it gives an answer that they don't like.
I'll get to the bottom of this.
In regards to the Second Amendment, as opposed to modern conditions in terms of, we stated before about domestic violence really not a problem anymore, of how would the originalist or view of it affect the interpretation of the Second Amendment?
I love the Second Amendment question. Because I think we have two very different Second Amendments. And the Supreme Court doesn't seem to see it that way. But I do think that in understanding what right is conferred, we should think about the purposes for which a constitutional provision was enacted. I mean, what the Supreme Court says with respect to federal gun laws, and that's what was at issue in the first case, because D.C. is governed by the federal government, sort of makes sense. So the big question for years has been, does the Second Amendment give a sort of collective right that's tied to service in a militia, or does it give you this individual right to possess guns, maybe for self-defense? And the answer as to the first question there, the answer with respect to federal law is, clearly this is about state militias. This is about preserving state militias as a potential military counterweight to the federal government. Now it's possible, and this is what the Supreme Court said, that the drafters of the Bill of Rights decided to protect those state militias by giving individuals a right to own guns. So the purpose isn't individual rights, but the way that they chose to achieve that purpose was individual rights. Maybe that's true, there's a big argument about that. The thing that I think is interesting is when you get to the Second Amendment as it's applied to the states, what do we think is going on there? So now we're talking about the Reconstruction Congress, right? Not the drafters of the Bill of Rights. They're concerned about the right to keep and bear arms. But is that because they want to empower the state militias to fight off the tyrannical federal government? No, obviously not. The Reconstruction Congress just got done defeating the state militias, using the force of the federal government. So they're not at all interested in empowering the state militias. What are they interested in? Self-defense. They're actually interested in self-defense when the state doesn't protect you, because they're thinking about freed slaves who are not protected from the Klan, who are not protected from the Night Riders. And they're interested in giving these people the ability to defend themselves when the state won't do it, when the state is maybe actually hostile to them. So with respect to state gun regulation, you got the Second Amendment. I think it really is about being able to defend yourself when the state won't do it. Now, this is maybe a bad constitutional provision because it doesn't fit very well with modern times. Or maybe it's not, because if you look at the way that the Supreme Court has interpreted and applied it, the only thing that they have invalidated is basically absolute bans on handgun possession. So we don't yet know what the Supreme Court is going to say the limits of gun regulation are under the Second Amendment. And the way our system is going, it doesn't look like we're going to find out, because the real obstacles to gun regulation seem to be political rather than constitutional, even if you accept what the Supreme Court has said about the Second Amendment.
I don't think I can improve on that answer.
Hi, great discussion tonight. Do you think in the pursuit of religious liberty, there's the right to discriminate against gay people in commerce?
My standard dodge, of course, is that I haven't studied the question sufficient to address it. I'm a libertarian. I believe, for what I'm probably going to get myself into some hot water, but I think historically discrimination has been fostered and encouraged by the state, and that's why you have free markets, because people should be, if you want to, I'm gay. I don't care that Chick-fil-A doesn't support gay marriage. All I care about is they sell chicken at the price that I like. That's all I have to agree with them on, because the beauty of a free market is it takes things out of politics, right? Well, look, if this was a situation like it was in the South, right, where the entire society was denying you service, so you couldn't get those services anywhere. But why was that true? Why was that true? Because it was government-sanctioned segregation. The segregation laws were written into the books. Such laws aren't written into the books anymore. Some localities do some weird stuff, like in Colorado in the Romer v. Evans case, but we don't have the same kind of situation, right? Now, maybe it would be different. Maybe we need an approach that says, look, if it's the only shop in town, you've got to do it. I don't know. This seems like a complex policy question. As for the constitutional argument, I am dubious that the Constitution can compel anybody to perform expressive services to anybody that they don't like for any reason. I'm dubious of that, but I don't know the answer. I don't know the final answer to that question.
My answer to that is no. I don't think that. I don't think that there's a religious liberty claim that should trump a state non-discrimination statute. And I think that for two reasons. One, which is maybe originalist. I say that I'm an originalist. I haven't done a whole lot of research on the original understanding of the Free Exercise Clause, because there are so many constitutional provisions out there. But it seems like a stretch to me to say that baking a cake, say, is religious exercise. Now, Maybe there's a free speech claim, although there again, I think we're stretching it beyond the original understanding. But I think it distorts the free exercise clause to say that being asked to do anything sort of inconsistent with your religious values violates your right to free exercise. I think really that was about, we want to practice our religion. Don't forbid us from performing the ceremonies that are intrinsic to our religion. Not let me shun anyone who my religion tells me is a second-class citizen. And even if it were the case that there's a constitutionally protected element of religious activity there, I think that gets balanced, you know. In most circumstances, your rights are not absolute. And if you go out into the world of commerce and say, here I am, I will serve all comers, you don't then get to say, except you, because my religion tells me that you're not good. So first, I'm not that sympathetic to the religious liberty claim in the first place. And even if I were, I think that it could probably be overcome by the state's interest in non-discrimination.
For what it's worth, in that case, in the Masterpiece Cake Shop case, the free exercise claim was actually relegated to the back, a couple pages. It was an expressive freedom case, a compelled speech case. And I do think it's much more a compelling case under the compelled speech doctrine than it is under free exercise. This is why I call it expressive freedom. But even then, it's probably a hard case.
Time for one more.
Both of you at some point seem to show, a lot of you expressed great interest in privileges and immunities clause. But Professor Roosevelt also seemed to have an interest in that as well. Is there anyone on the courts these days who professes an interest in promoting the use of the privileges and immunities clause?
I would say Justice Thomas, but it's not clear to me his understanding is the correct one. But we don't know. But he does. I don't know that it's wrong either. You know, I haven't studied his privileges or immunities opinions enough. But he has expressed interest in reviving them. A lot of that is driven actually by an ideological movement among libertarians to protect economic liberties. I think even if the privileges or immunities clause is recovered, I don't think it protects as much economic liberties as a constitutional matter as my fellow travelers would like it to. But it's a tough question, but as to the merits, but Justice Thomas has expressed interest. I don't think anyone else has.
Yes, that's also my understanding.
I did see one more hand. Sorry.
I actually don't think I need that.
No.
Yeah. I have a question more about process than the actual document. I would like your opinion about if there was one thing you could change about the process by which these justices get nominated, selected, or the pool from which they're chosen to make it a better, more representational, more originalist. What would you change?
Just so everybody heard the question, if there was one thing you could change about the process of selecting justices to the Supreme Court, what would it be?
Well, the main thing that I want to change is life tenure. I want them to have 18-year terms so that you get regular, predictable turnover that has some relation to who's winning national elections. But that wasn't your question. In terms of how they're selected, I can't think of something I would do about that, really. I mean, what I would like to see would be a greater diversity of career experience. Because at the moment, we're getting people, well, Brett Kavanaugh's an exception, actually, but we're getting people who've spent most of their life in the federal judiciary. And that's not so good, because it means that they don't understand how the other branches of government work. People are concerned about justices who come with experience in the executive branch because they're afraid that those justices will be too deferential to the executive branch. And that is a real concern. I mean, the thing that might be really good would be people who have experience in state government, because that's what is really missing on the court. Sandra Day O'Connor had experience as a state legislator. Definitely you could see that in some of her federalism opinions. But experience in state government is what I would like to see more of, I guess.
I'd probably get rid of the cameras. I mean, I don't know, in the confirmation hearings, George Sutherland, I guess, was nominated and appointed in the 1920s. He was overseas when he was nominated, and he showed up in the United States and got a letter saying, you've been confirmed, go to your new job, we hope you accept it. And you know, maybe there's some virtue to that, but again, so long as as judges engage in political decision making, if you agree with that premise, then I think we should have confirmation hearings, but maybe they'd be more sensible if there weren't cameras. One thing I will say is, again, I think the confirmation process as it is today, not among justices, but among lower court judges, who, by the way, usually is the pool, constitute the pool from which you eventually get Supreme Court justices, has a heavy tilt toward people with litigation experience. Who are the people with the most litigation experience? Prosecutors. Prosecutors like Justice Alito, who I'm not sure has ever ruled against the government in a criminal case, you know, even though he's probably an originalist. I mean, I think we need a broader test than your litigation experience to become a judge and subsequently a justice.
I thank our guests, and I want to thank all of you. The process that we've been watching could be dramatically improved if the issues could be discussed the way these two gentlemen have. So, thank you very much.